Good morning, and thank you so much for joining our discussion today on TikTok, teens, and spying machines, fear of foreign apps. I am delighted that so many of you have joined us for this important discussion. As mentioned, we've had an unprecedented amount of interest. Thank you for your patience. My name is Hillary Brill, and I lead Georgetown's Institute for Technology, Law, and Policy, a think tank at Georgetown Law, where we focus on providing deep expertise for students interested in technology policy and law. We engage, in independent research on interests in issues at the intersection of law and policy. We convene, like our panel today, thought leaders, policymakers, civil society experts, and press on such issues as AI and bias, digital inequities, privacy, and national security issues like today's topic. This is in a historical moment where a widely popular teenage dancing app has caused fear in the highest ranks of our government and led to a presidential executive order. This has raised immediate questions. What ramifications, planned or unplanned, result from such an order? Is the president empowered to enforce this order? Why now? And why these specific companies, WeChat and TikTok? To set the stage for today's discussion, a little background is in order. TikTok boasts 800 million users worldwide and 100 million in the United States. It's a social media platform that allows sharing of videos with overdubs of popular music, memes, or other audio-video clips. It is perhaps known mostly for its use by teenagers for dancing competitions or Fortnite videos, but it is used by teens and adults for entertainment, education, and even social activism. WeChat is a messaging and e-commerce platform with over 1 billion users worldwide, but a much smaller presence, however, in the United States. On August 6th, Trump issued 2 exec orders prohibiting certain transactions with specifically TikTok and WeChat, popular apps owned by Chinese companies. The executive orders assert that these apps pose a threat to U.S. national security by collecting data on users and making it available to the Chinese government. And the order relies on what you will hear, the International Emergency Economic Powers Act, known as IEEPA. And they use this as the authority to force these apps out of the US marketplace. The President Trump's executive orders targeting these companies came on the heels of its, quote, Clean Networks, end quote, initiative, which was announced on August 5th by Secretary of State. That initiative is aimed at safeguarding consumers and companies' information from Chinese surveillance and interference. Among other elements, it includes a clean apps component, which these executive orders intend or appear intended to implement. These executive orders present a number of fascinating and critical issues at the juncture of national security, freedom of expression, and the limits of executive orders. And of course, these national security measures are only part of the mounting tensions between the United States and China, with tariff and trade issues and accusations relating to the spread of COVID-19, all are playing an interrelated role. Our esteemed panelists today will help decipher and decode these complex issues. And we are fortunate to have, leading our conversation, our moderator, Professor of Law, Anupam Chander, who is an expert on the global regulations of new technologies. He's a recipient of Google Research Awards and Andrew Mellon Grant on the topic of surveillance. He has served on the World Economic Forum expert groups on digital economy, and he also serves as a senior research scholar at Columbia University School of International Public Policy and as a faculty affiliate at Yale Information Society Project. We have Tiffany Lee, a fellow at Yale Law School's Information Society Project and a clinical professor at Boston University School of Law. Lee's scholarship focuses on privacy, artificial intelligence, cybersecurity, and technology platform governance. She is regularly featured as an expert commentator in global and national news outlets on global and tech law and policy issues. And she has worked with Princeton and Berkeley Center for Tech, Society, and Policy. We have Hina Shamsi, the director of the ACLU's National Security Project, dedicated to ensuring U.S. national security policies and practices are consistent with the Constitution, civil liberties, and human rights. We have Professor Julian Koo, the Senior Associate Dean for Academic Affairs, the Faculty Director of International Programs, and the Morris A. Dean Distinguished Professor of Constitutional Law at Hofstra University. Professor Ku has conducted academic research on a wide range of topics, including China's relationship with international law. He has been the co-founder of the blog Opinio Juris and contributing editor to Lawfare, a leading national security blog. And we have Professor Robert Chesney, the James Baker Chair of the Rule of Law and World Affairs at the University of Texas School of Law, where he also serves as the Associate Dean for Academic Affairs. Separately, he serves the broader university as director of the Robert Strauss Center for International Security of Law, and he's the co-founder of the national security blog Lawfare. With that, I will turn this over to our esteemed moderator, Professor Chander. Thank you.
Thank you so much, Hillary. That was a terrific summary. So on the day that we learned that our nation had suffered its greatest economic collapse in any quarter in recorded history, President Donald Trump announced that he was banning TikTok, an app popular with teens. That was July 31st. That weekend, Microsoft CEO Satya Nadella placed a call to the president and asked him if Microsoft could buy TikTok instead. And the next day, the president said he would want a brokerage fee if any such sale occurred. So in the span of 3 days, Trump announced a ban, a reprieve, and a shakedown. A few days later, the president issued an executive order declaring a national emergency because of the threat posed by TikTok. For good measure, he slipped in another executive order without any prior notice, declaring a national emergency due to WeChat. That was last week. That was Thursday. This week, the president told Conservative Talk Radio on Tuesday, if I don't win this election, China will own the United States. You will have to learn to speak Chinese. So that's the context in which all this is occurring, and I want to return to that political context. But we have an alphabet soup of law first to uncover and understand. And I wanted to turn to Bobby Chesney to help us explain that alphabet soup. So IEEPA and CFIUS are two critical piece of architecture for understanding our national security law. And Bobby, as a national security expert and the founder of Lawfare, can you tell us what is about the move from CFIUS to IEEPA as the basis for these executive orders?
You bet, and thanks for having me on. So CFIUS is the Committee on Foreign Investment in the United States. Think of it as an interagency regulatory body that's charged with reviewing transactions that involve foreign entities where the transaction might have implications for U.S. national security. It can block a purchase agreement, for example, from being executed, but it can also come in after the fact, as it is doing in this case, where the agreement has already culminated, but it's a retrospective review. And the ByteDance acquisition of Musical.ly, which then became TikTok, that's been an issue since last fall, when around the time of intense controversy surrounding Hong Kong, it became apparent initially through a Washington Post report that it appeared TikTok's content moderation practices might be suppressing coverage of the protests in Hong Kong. And then a Guardian story that was quite a blockbuster revealed a TikTok content moderation policy document that was very disturbing in many respects. This then accentuated concerns about whether ByteDance, the parent company, would be obliged to cooperate with Chinese Communist Party requests for information production that could then reach through into TikTok. And this led to a post hoc CFIUS review of the ByteDance acquisition of Musical.ly, which was back in 2018. Now, it's unclear what outcome that review would ever have reached or when exactly that review would come to a head. And that might help explain why the president ultimately last week didn't rest on CFIUS, turned to this new mechanism that was at his disposal, the International Emergency Economic Powers Act, or as we affectionately love to call it, IEEPA. So with IEEPA, the way to think about it is there are a couple of steps to using it. First of all, the president has to turn it on, and the way it gets turned on is by a public proclamation of a national emergency on a given subject. to be clear, this is not the sort of thing, for better or worse, that is ever successfully challenged in court. There's tremendous discretion. And that's been the subject of intense criticism in our public discourse in recent years. For example, when this same mechanism was used to redirect money towards wall construction on the southern border. So the declaration of emergency makes it possible for the president to impose sanctions, but it doesn't actually impose the sanctions. You need a second step. And the second step can be implemented in a couple of different ways, and it's relevant here. So on one hand, the president can directly impose a sanction. He could announce the emergency, name the relevant entity, and identify what the sanction is. Maybe the sanction is freezing of assets that are within US jurisdiction, or maybe the sanction is prohibition of any and all commercial interaction or transactions with the sanctioned entity. But it doesn't have to all be done at once. What you can do instead, and what often is done instead, is there's the emergency declaration, and then there is a directive by the president to, say, the Treasury Department, or in this case, the Commerce Department, to build out a sanction system where there will be regulations spelling out how it's going to work. And then from time to time, as the facts evolve and when the relevant department determines that it's necessary in a particular case, then at this later stage, some particular entity gets named. I mention all this because that creates room for leverage. It creates negotiation pressure. It functions as a credible threat. And last year, 2019, in I think it was May, the president declared a national emergency about supply chain security risk involving information and communication technologies. But he didn't then name particular sanctioned entities. He created the national emergency, directed the Commerce Department to develop a system, and then later, perhaps, maybe Huawei would get sanctioned, maybe TikTok might have been sanctioned. But that process requires promulgation of regulations that have been pending for a while now and aren't out there yet. So when it came time for when the president decided to take action last week, he didn't have that completed IEEPA system in place to act. And so what he did when he sanctioned both TikTok and ByteDance and WeChat and Tencent, maybe we'll talk about whether Tencent's really involved here or not later, I'm sure, was to sort of go back to the original national emergency declaration and then short circuit the framework process that has been pending and just say, okay, under that same emergency I declared last year, I'm going to go ahead and jump right to naming TikTok and WeChat as threats now. And then there's the further step. So what's the sanction? And that's where it gets even more complicated and interesting. On one hand, the sanction's clear. It's not described as an asset freeze. It's a ban on all transactions. So far, so good. But we've entered some new territory here because we're talking about apps. They're used by, well, teenagers across the country, among others, in the case of TikTok, and then just about the entirety of the Chinese diaspora around the world with WeChat and a lot of Chinese speakers, a lot of businesses that are trying to reach Chinese audiences. There's this huge user base that is wondering, are we now is it a crime in a certain number of days for us to use these apps in violation of the IEEPA order? Both orders for TikTok and IEEPA specify that within 45 days, so basically early to mid-September now, the Secretary of Commerce has to promulgate basically an explanation as to what they mean by all transactions. And they can go real broad or they can go real narrow, and we don't know. So why don't I stop there, having spelled that out?
So much, Bobby. That was a terrific summary of the complex legal landscape here. And it raises questions. The speed of all this raises questions about, what the purpose of all this is. Hina, you guys at the ACLU have been stalwart defenders of free speech. These particular executive orders target two apps on the basis of privacy and security. They're saying these apps are a threat. They're a surveillance threat, and that's also another key question that you guys have always at the ACLU have been concerned about. So what should we make about President Trump's declaration of speech and privacy as being the concerns with respect to these two Chinese-owned apps?
Thank you so much, Anupam, and thank you so much for having me. The short answer may be fig leaf, but let me elaborate a little bit more and provide some context, including with respect to IEPA, which is a statute about which we have long had very, very significant concerns stemming from the fact that it is vague, it is overbroad, presidents can claim too much power under it, and it can be used for political and discriminatory purposes in response to real, perceived, or hyped threats. And I'm thinking, especially, when I think about this context, about the ways in which it has been used, for example, by President Bush, who issued an executive order under IEPA establishing a sanctions regime that was used largely against Muslims and Muslim organizations in an earlier period. As they say, I'm old enough to remember, in part because my colleagues and I litigated one of those lawsuits. And what we argued was that when these kinds of sanction regimes are applied with respect to Americans and US persons, which can include legal permanent residents and others who have constitutional rights by virtue of their presence or connections to the United States, the Constitution applies. And the Constitution applies specifically, we're going to talk about the First Amendment, but also there are First, Fourth, and Fifth Amendment safeguards against seizures of property, as well as requirements of due process and notice that often get, aren't given enough attention to. And Bobby, as you'll remember, we actually won that lawsuit. And so, in fact, there is that precedent on the books. Unfortunately, under the Obama administration, that incorporation of constitutional safeguards was not reflected in the regs, much though we and others wanted it to be. So now you come to a president who is egregiously lawless, xenophobic and racist in his agenda, who has invoked emergency powers for, as was mentioned earlier, things like the border wall, which also violates the Constitution in other ways and subverts the intent of Congress, or to prevent, invoking emergencies to prevent accountability in sanctions regimes, for example, with respect to the International Criminal Court. And potentially sanction regimes there. Here, what is critically important is that the terms emergency, national security, and threat are being used in ways that are vague, that are not substantiated with specificity or evidence with respect to American interests. And what is at stake when we're talking about IEPA as well, Bobby so rightly pointed out the specifics of the regime and that things remain to be defined, right, including any transaction. How will WeChat's parent company be specifically impacted, and what will the impact be on other holdings? But what we do know is that IEPA has what us lawyers think of as a strict liability enforcement regime, which is that civil penalties may be incurred even if people don't intend to violate the ban that is put in place, and there can be criminal penalties if the violation is intentional. Hillary rightly pointed out the millions of users for TikTok and WeChat in the United States, people with First Amendment rights. And that, let's just be specific. People watch or post videos to TikTok. They rely on WeChat for connections to family, friends, work relationships. They play online games. All of those things are First Amendment protected expression, speech, association. And the apps mean a lot to users, right? They derive joy, connection. people who are influencers can get fame and earnings. And all of these things implicate First Amendment, and banning an entire or two entire platforms, right? Yes, there's the lack of clarity, but this is in many ways unprecedented. Privacy seems not to be a legitimate issue, because if it was, then the government would actually address the privacy issues. Let me put it this way. It is true that the Chinese government suppresses dissent. It censors people. It is authoritarian and rights violating. And that's mostly against its own people. It is also true that TikTok and WeChat sweep up different kinds of data. So do Facebook and Google and other American companies. If this was about privacy, we might be thinking about surveillance reform. We might be thinking about consumer privacy legislation. That's not what this does.
Great. Thank you. That was terrific. Julian, you have been a leading scholar on issues of international law. And so tell us a little bit about whether the president has this authority at all to ban these apps. This is Bobby said this is a different exercise of IEPA than we've seen previously. And we saw CFIUS used with respect to Grindr, but we haven't seen IEPA used in this kind of way. Does the president have the authority to ban a social media app?
Thank you so much, Professor Chander. Thank you, Anupam, and I really appreciate the chance to sort of share my views on this, because this really unites two of my interests. One is executive power in foreign affairs and national security, and the other is, these days, everyone's interested, I guess, in U.S.-China relations. And so it's been a great collision of things I'm interested in. I guess for me, IEPA, just to take a step back, just to give a little bit even more context than Professor Chesney gave, IEPA really is just a remarkable statute that confers just enormous powers. And I agree that with that it's remarkable, and then probably Congress should claw back some of this power. However, we need to remember IEPA was itself considered, when it was passed in 1977, as a much more restrictive statute than the prior statute, the Trading with the Enemy Act, which had been enacted in World War I, which gave even more power. Almost unbelievable amounts compared to IEPA, which no requirement of Declaration of National Security, very few sort of requirements of transparency to just disclose what exactly you're banning and why. So while IEPA is remarkable, if you see in the context of it was intended to actually cut back on the president's power, it gives you the baseline of where IEPA is coming from. And IEPA is, but if you look at the language of IEPA, it's the president must declare an unusual and extraordinary threat to national security, foreign policy, and the interests of the United States, and the economy of the United States. So it's not even just about national security. The threat could be to the economy of the United States, and Congress has granted the president under IEPA in 1977 the authority to declare a threat with respect to a broad range of interests beyond just national security. And I think this has never really been explored, because I think although there has been litigation with respect to the particular applications of IEPA, as far as I understand, it would be quite difficult, and I think it would be almost impossible to overcome, to challenge the president's determination that there was an unusual or extraordinary threat to national security, foreign policy, or the economy of the United States. When Congress hands the president that kind of statutory language, it's intending to confer on the president enormous sort of discretion in making what are essentially policy judgments. Now, I think there are good ways that can be challenged with respect to its application and giving due process and the regulations. Maybe this person really isn't part of what the order meant to be, but I think the declaration of a national emergency is quite, with respect to these three categories, confers enormous discretion. And Congress, the idea behind IEPA was to give the president this power, force him to be transparent about it so that he can't just do it in secret, declare what the emergency is, and then Congress was supposed to be the check. Congress was supposed to be able to terminate a declaration of national emergency by joint resolution. Now, there's a subsequent constitutional law decision called INS versus Chadha, which kind of ruined everything for this strategy, because all these statutes are passed in 1977. Chadha, which I'm beginning to think is probably a bad decision, actually, if you think about it, made it difficult for Congress to simply terminate a statute without having to go back and override a president's veto. In other words, under the old version of IEPA, the Congress could just terminate it by majority vote of both houses, a legislative veto. But now, under the Supreme Court's interpretation, they have to pass a resolution which the president can veto, and so therefore makes it much more difficult for the president to, for Congress to terminate IEPA. It's also worth noting IEPA was passed a few years after another great resolution intended to cut back on executive power, the War Powers Resolution. Similar era, similar strategy. Both have not really been able, Congress has not been able to use that power to cut back. But I guess from a legal point of view, my view is that this was intended to be, especially given the history, it was intended to confer this kind of discretion on the president. And if you look at the statutory language, with respect to determination of whether something is an unusual or extraordinary threat to national security, foreign policy, or the economy of the United States, I would find it really difficult to imagine a court would be willing to second guess that kind of determination. If we look at other, and it's not just President Trump, although it's tempting because he is so unusual in so many ways. But you know, it's been really been expanded and really used willy-nilly for almost everything. I mean, I think it's probably been President Obama in 2011 declared transnational criminal organizations are an unusual and extraordinary threat. What happened in 2011? Well, there's some cyber hacking, there's some concerns about narcotics trafficking. He just said, all right, every transnational criminal organization poses an unusual, extraordinary threat, and we now have the power to sanction them. So I think it's really been used across parties, across administrations, very broad ways. You know, it's been used 50, 60 times. And most of them actually are similar to this one, in fact, which I think is really, I think, where it can be most well defended, I think, in disagreeing a little bit with, you know, which is that a lot of these IEPA orders are directed at foreign governments, which are pose some sort of danger in the judgment of the president. And the foreign government is acting in a hostile or nefarious way. And that's why the US government or the president declares a national emergency. And that kind of makes sense. Iran was the original IEPA target. What did Iran do? Iran did a lot of things, including seizing the US embassy. President Carter declares IEPA emergency. And that was sort of the classic case. And so if a foreign government shows hostile ill intent, then I think the IEPA was intended to sort of allow the president to take economic measures to not just protect US citizens, but also to protect US interests. So it's intended to be broader than even just protecting the rights of US citizens or privacy of US citizens. Actually, it could even just be foreign policy interests or national security interests outside the United States, at least under the language of the statute. And so I think in that light, if you look at it that way, and maybe I'm a little bit by myself on this island here. You know, I mean, look, we have a declaration about Burundi. What did Burundi ever do to us, right? You know, like these emergencies have been used by presidents, and that wasn't President Trump. You know, there were presidents for almost everything. And now I think maybe we should cut back on it. I think Congress probably should cut back on this, but I think under the current statute, it's pretty broad. And having said that, with respect to China, and I think this is what's really changed, and this is how it can be justified. Something has changed with China, bringing me back my other interests. The Chinese government WeChat is not the problem, TikTok is not the problem. The problem is, and the unusual extraordinary threat is the Chinese government. I think what's changed, I think this is something that I don't think a President Biden would necessarily have been different about, or will necessarily be different about, is that the Chinese government has demonstrated a willingness to use social media, to use personal data, both at home and in the United States, to conduct espionage, to recruit sort of agents. So the famous stories about Chinese just send you LinkedIn messages saying, hey, you want to do some consulting, government employee? And believe it or not, these US government employees are like, yeah, I'll do that. Some random person on LinkedIn, right? I don't know why they do this, but so they hacked into the Office of Personnel Management, got all the individual personal records of US government employees. This is the US government. This is not just Trump's imaginings. This is something that occurred during the Obama administration. And we know that the Chinese government does have the capacity to leverage using AI and high technology to use personal data in a way to advance its interests in ways that are hostile to the United States. And again, it's not even just about privacy of individuals. It's about using that data in a way that would advance its interests in a way that's negative to the interests of the United States. So I think if you think of it in those terms, that the Chinese government is the target here, and that WeChat and TikTok are, unfortunately for them, unusually vulnerable to exploitation by the Chinese government in ways that Facebook is not, then I think that explains why you might distinguish between TikTok and WeChat versus Facebook. And that's, I think, now, you might still want to protect Americans from Facebook, but it's a different threat. And I think that's why I think, and the executive order is really only about protecting the United States against foreign threats, foreign government threats for the most part, which is what IEEPA was supposed to be about. So I guess for me, I generally have I'm not excited. My daughter is really bitter about this TikTok problem, and so she's not going to be happy with me. But I do think that there's a reason, given the way how broadly IEEPA has been used by presidents across administrations, given the extraordinarily broad language, given that it does actually restrict the president more than the prior regime, which existed under the Trading with Enemy Act. Yeah, I think as a legal point of view, I would be surprised if there could be, that this is that there'd be any sort of reason to overturn this order in court. Now, having said that, I do think, one thing I'll just say, I do find the combination of IEEPA with CFIUS and using them together a little bit more troubling than, and this idea of, if you don't do this, if you don't sell, we're gonna act through IEEPA. Although again, I'll just note that we do have in the United States a long history of requiring nationality requirements for certain kinds of industries, including broadcast industries like radio, TV, right? You actually have, the FCC has the authority to block, to refuse to give someone a license because of their because the company's nationality, which seems like discriminatory, but has been a long-standing. Poor Rupert Murdoch had to become an American citizen not poor Rupert Murdoch, but Rupert Murdoch had to become an American citizen in order to buy media properties. So there is this historic tradition in the United States of doing this. Airlines also, we have nationality requirements. So a nationality-based ban on apps is actually not a social media, which is, is it more powerful than broadcast media? Probably. It's not unreasonable if you look at that long baseline of US nationality restrictions. So I guess for me, I'm not as troubled by this. I am a little troubled by the idea of taking a finder's fee and using IEEPA as some sort of, I'm not just troubled by that, that's just wrong, right? And it's crazy, but it's not even the craziest thing that's happened in the last 2 weeks. So having said that, so we got a lot, but I think in general, I think the IEEPA order with respect to TikTok and WeChat is not an unusually extreme exercise of the president's power, given the unusual extraordinary threat. I think that is being revealed by what the Chinese government is doing in the last years.
Great, thank you, Julian. That was terrific. I do wonder, however, if we start banning a foreign app because of its nationality, that we're borrowing not from what we have done in the past with respect to Rupert Murdoch, but rather borrowing from what China has done in the past with respect to YouTube and Twitter and Facebook. That's what it feels like, and not exactly making Rupert, take on American citizenship. TikTok is, as you know, an American company. It's incorporated in America. It has, it's building out a huge American workforce. It has an American CEO, an American, a security officer, blah blah, down the executive ranks, trying to put out people that should be more, comfort the American government, including their chief legal counsel from Microsoft, et cetera, which might make it easier to sell to Microsoft ultimately, as it turns out.
No,
but just to summarize,
just a quick note, but if you think about licensing for radio stations or TV stations, it does seem crazy that you have to be a U.S. citizen to do that, but we still sort of require that. And why can't Singapore Airlines, form a subsidiary and fly us much more nicely to LA than, so we do. I'm just saying that we do this. It may be crazy, but we do this. So.
Yeah, I would endorse Singapore Airlines, except that it's always too expensive for me to fly. So just to summarize quickly, because I know that we have discussed a ton of stuff that, we have an audience of experts like Joel Trachtman is asking a technical question, but we also have, hopefully teenagers in the audience. And by the way, my teen daughter is very happy with me as with respect to the TikTok saga. And so, you might consider revising your views to please your child. Here, the summary would be, you've got CFIUS, which was a committee, as Bobby described, that reviews foreign investments coming into the United States, because ultimately the TikTok investment as a foreign investment in the United States, that committee had been operating, trying to examine whether or not there was a national security implications to that investment. The committee hadn't made a decision, and the president instead turned to an alternative, which was this statute, IEEPA, as Julian has said, has given extremely broad powers, a kind of blank check in some sense, perhaps unreviewable, Julian says, for courts or Congress to say, to not be able to review the president's declaration of a national emergency, and then broad sweeping powers after that declaration, including possibly the power to ban transactions with that format. And we're awaiting now the Treasury Department to kind of, as Bobby has described, spell out those orders. Has said she believes there is a challenge. There are legal challenges that are available to TikTok and its users. And those legal challenges include the First Amendment, the Fourth Amendment, and the Fifth Amendment. And the Fifth Amendment would be a due process challenge to this kind of taking. And so all of those, and Julian and as you can see, disagree the nature of those challenges. I think that's really important. That will ultimately, if this goes forward, be resolved in the courts, obviously. So, Tiffany, with that kind of backdrop, you are a leading scholar of social media, and so you followed these apps longer than anyone here, and understand these apps, I think, better than anyone, maybe Julian's daughter accepted. And so tell us about the privacy and speech questions about a ban. Does a ban undermine or enhance privacy and speech?
Sure. So also, thanks for having me. This is a fun discussion so far. And I was interested when Julian said that this issue related to two of his favorite interests, because it also relates to two of my favorite interests, which are entirely different. And those are consumer privacy and global internet norms. So on that front, we have a few interesting things to talk about. For TikTok and WeChat, we have radically different types of apps that are being banned right now. TikTok is primarily a content application. People create videos, they remix other videos, they use music, they use editing effects. It's really a fun, engaging platform, but it's really more like YouTube. It's not so much like Facebook Messenger or something like that. On the other hand, WeChat is much broader in scope. So WeChat includes communications, payment, e-commerce, games, and more. So these are very different apps. And if we're thinking about this in terms of national security risks or global internet norms, they're very different. Additionally, I think what's really key is that TikTok is aimed at a global market. So TikTok doesn't really operate within China, and there isn't competition in that way. China has its own version of TikTok that existed before it. On the other hand, WeChat is basically limited to a Chinese market plus the Chinese diaspora. So again, very different economic concerns as well. So when we think about privacy, we hear a lot about all the terrible things that TikTok is doing. And I think what people always mention is things like TikTok giving data to the Chinese government potentially, or TikTok harvesting more data than it promised it would do in the privacy policy, or TikTok not protecting children's privacy in the way that it promised to do in their privacy policy. These are all pretty bad things, but I think what some of other panelists have already mentioned, these are things that US tech companies do as well. not necessarily giving data to the Chinese government, but passing data to the US government under reasonable government requests, under lawful request regimes. And sometimes our US-based tech companies also violate some of our privacy rights. They don't protect privacy the way that they promise to in their privacy policies. They accidentally give third-party permissions to third-party developers who have, less than ideal goals. For example, I think we all remember the Facebook and Cambridge Analytica controversy last year, where Facebook was found to have allowed third-party access, third-party app developers to access a trove of private user information, more than they had promised that they would allow within their privacy policies. So what's the main difference here? If both TikTok and Facebook are giving a lot of data to a lot of sources that we may not know as consumers, what's the main difference? Really, the only difference here, well, two differences. The main difference is that TikTok still has a connection to China, right? The parent company is still a Chinese company, even if TikTok as an entity is US-based. Similarly, WeChat is definitely based out of a Chinese company and not US-based at all. That's a key difference in terms of where the data might be going when we don't know where it's going. So that's something to be concerned about in terms of national security. However, again, the data that's being lifted potentially from these two sources may not be that much data or data of a different kind than other apps give out. So that's something to think about. The other difference, though, between TikTok and Facebook, or between WeChat and WhatsApp, is really just the age of these apps. So TikTok especially is a very young app. And in terms of things like speech and content moderation, TikTok hasn't really figured it out. And this is something a few other panelists have alluded to. TikTok has been found to have relatively what some would call discriminatory policies in content moderation. They've had different policies that have been leaked to the press that have said things like content moderators should downrank content that belongs to or shows people who are disabled, people of color, queer people, and more. These are not ideal content moderation norms. I'm pretty sure that if a US company had that kind of content policy come out to the press, we would all be extremely upset about this for a variety of reasons. But it's not necessarily true that TikTok is out there to create a bad speech environment. Political concerns aside, some of these content moderation problems are just the moderation problems of any young startup. And we've seen this with Facebook, with Twitter, with everyone, that when they're first starting out, they don't quite know how to moderate content, especially moderation of content at scale. At the scale that these companies are operating on, with hundreds of thousands of posts, it's very difficult to moderate in a way that provides a healthy speech environment. But we still can't ignore the fact that these companies are inextricably linked to China or based in China. And I think what I would like to end with is really just going back to an op-ed that Anupam wrote recently for the Washington Post, which I thought was great, speaking about the idea of these global internet norms and what we're doing when we decide that certain companies should be banned based on national origin. So this is a twofold problem. On one hand, you have the idea of these Chinese-based companies creating global internet norms, creating norms for speech, creating norms for privacy. For example, WeChat is not end-to-end encrypted, which means that the company can see communications and potentially there may be backdoor government access as well. That's a privacy and security norm that potentially is now being spread out to the rest of the world. So on one hand, we have these Chinese-based companies spreading internet norms to the rest of the world. On the other hand, we have this norm that the US has previously been a champion of, this idea of a free and open internet, that anyone should be able to log on and say, Google whatever they want. They should be able to look at Wikipedia and read about anything in the world and learn and communicate and share and access information and have free expression on the internet. That's a vital norm the US has been a proponent of. But right now, if we start banning certain apps without due national security cause, we're no longer promoting that norm. We're no longer the free and open internet speech defenders. And that's something I think that we should be concerned about, because that's a norm that's really negative, has very negative effects for the future of the internet.
So terrific. Thank you, Tiffany. I think, and thank you so much for citing my op-ed, of course, but thank you for those really great insights. My daughter, who is an avid user of both Instagram and TikTok, says that actually the thing about TikTok is that it makes her feel good, and there's something about to kind of give you the stuff that it thinks will make you feel good, and everyone feels good looking at different things. I like kind of interspecies romance, dogs and cats having fun together. So things like that. So okay, so we have a set of wonderful questions that are coming in. We have a short amount of time remaining. So one question that I think is important, and this picks up exactly on Tiffany's point that she closed with, the decision and this is Ewan Sutherland, this decision looks like a great precedent for a foreign government to use against Facebook, Google, Amazon, or any other firm it might dislike. And I'm going to turn it over to Julian, actually, because Julian, you pointed out the problems of these apps, the Chinese apps. But the worry is, what about the problems of the Americans as the rest of the world looks at our dominance?
Yeah, so I guess this actually builds on what Tiffany was saying about giving up global norms, and in your point as well. I mean, it might be troubling if, but China's already maybe the largest single internet market in the world, and China has never really signed on to these global norms. And China already, since the beginning, has banned Facebook and Google, and Twitter, and by the way, they've blocked the New York Times and BBC. I mean, they block a lot of stuff, right? So, I mean, I don't, so, and look, we've been talking about global norms since the beginning of the internet, and it's had, as far as I can tell, zero impact on changing China's behavior with respect to internet governance. So, yes, we lose out, but I don't feel like we lose out as much as it might seem. And like, for instance, just take another example, India just banned 59 Chinese apps based purely on, a reaction to like this horrible incident on the border. But still, like India just said, well, we're just going to ban it. And I don't think they were worried about the global norms either.
Right, and India described it as the news media in India described it as a digital strike, as opposed to a kinetic strike on China. And so kind of interesting. And as everyone here knows, the executive order actually cited the Indian ban. The US executive order cited the Indian ban as part of the justification, as support for our own actions, which is quite interesting. Joel Trachtman, one of our amazing colleagues, asks a very technical question. I'm going to pose this to Bobby. So there is this weird exception in IEEPA for communications and information technologies. When it doesn't have, there's no transfer of value. What do you make of that exception? That is, one way to read that exception is to say, oh, IEEPA just doesn't allow, despite its sweeping authority, it doesn't allow you to sanction communications technologies, and this is a communications technology, and therefore it's outside IEEPA. But there's a narrower way to read that as well. So I'm just curious how you read that exception in IEEPA.
Great question. I'm glad Joel raised it. So this is in 50 U.S. Code, section 1702, B1 and B3. I don't think these are fairly read to refer to communications technologies or platforms or infrastructures or business models to facilitate communication. These are designed to prohibit IEEPA from being used to actually prohibit a communication itself going from a sanctioned entity to or from a US jurisdiction person. So for example, notwithstanding the sanctions, TikTok as an entity, ByteDance as an entity, et cetera, can't be prohibited from sending a communication to you or you communicating to it. But it doesn't follow that those companies are immune from IEEPA sanctions authority insofar as they establish business operations within the United States. I don't think there's any question that these limitations on IEEPA do not prohibit the president from using the sanctions authority, the broad sanctions authority that Julian mapped out as being delegated by Congress, from prohibiting foreign entities from actually having places of business, employees, contracts, leasing of servers in Virginia to facilitate their business. again, we have to distinguish between the infrastructure and business operations, which I think clearly can be prohibited and are being prohibited here, and the act of a particular communication between the sanctioned entity and the U.S. individual.
Great. Hina, we have a question about whether the administration has outlined publicly, with some evidence, the manner in which TikTok and WeChat are a threat to national security.
Sure, Anupam. Can I just also respond to Joel's question a little bit, because I've been focusing on that too, and I would prefer Bobby's read, but I am worried that that read would not apply, just given how any transaction and sanctioned regimes have been implemented, and would worry about how a personal communication involving a thing that is not of value could be read to apply in this particular context, because communications over TikTok, WeChat, they're valuable to the people who communicate them, right? And I admit that I am coming to this with skepticism about this administration and how it has previously interpreted its powers and twisted language and words. With response to the question about some evidence, you know, I think what's notable about the executive orders is when you parse through, there is both lack of specificity and lack of actual evidence with respect to US interests versus supposition about what might happen. And those things are really important, because when we go into supposition, then all sorts of discretion opens up that can be abusive and arbitrary. And I take very seriously Tiffany's points about, you know, what the specifics of these apps are, how they are used, and how data is gathered within the United States, or how they're used within the United States, and how the logic of these bans breaks down when you think about the similarities and differences with respect to what US companies are doing and what we know of about WeChat and TikTok with respect to the US. There may be reasons for concern, but they're certainly not fleshed out in these executive orders.
So I've been, you know, one of the executive orders mentions search histories as one of the concerns. And as far as I can tell, and I've kind of inquired about this and tried to understand what the reference is to search histories, because it would be truly alarming if TikTok is sending all my Google searches to, you know, some foreign power. But I don't think that's what's actually happening. I think the reference to search histories here is the searches inside the app. So when you do a search within TikTok, that information is available to TikTok's, you know, designers, depending on their own internal processes, et cetera, right? And there, I think there's a kind of almost an intentional obfuscation by the government of what's actually happening. If it's search histories in the app, that's the reference. It's like no duh. You know, the app knows what you're searching for. It kind of has to know what you're searching for in order to respond. So I'm a little worried about the actual evidence here that's offered, and the kind of the lack of detail and almost intentional obfuscation of whether it's serious. And I'm also very concerned in this context about the fact that this is a few months before the election. When I think of the question that Joel Trachman poses about communications being exempted, I'm thinking really targeting Sarah Cooper on TikTok. And so Sarah Cooper has used TikTok in a masterful way to troll the president. You know, it's not, you know, if we think of one app that Trump doesn't have a huge number of followers on, He has huge number of followers on Twitter. He has huge number of followers on Facebook. Facebook has apparently lots of QAnon, or however you pronounce that, crazies on it. TikTok, and then WeChat, which is it seems to be a kind of miscellaneous thrown in to kind of support the logic of the TikTok ban. It happens to be an app that's largely people who have used it to humiliate the president, not to support him. And I think that feels highly problematic in this kind of election context. And in the context, so Bobby, you described one of the questions that's been posed here, and I'll return to one of the questions, is the next steps from the executive order. There's a question of the Commerce Department or the Treasury Department taking the next steps. And can you tell us a little bit about what's happening in those next steps and why one would choose Treasury or Commerce to implement the sanctions?
So in this case, it's the Commerce Department. There'll be consultation with others, but it's the Commerce Secretary who ultimately is going to promulgate some sort of document. According to the terms of these orders, it has to happen after the 45-day mark. So on the day that these bans become operative, at that point, it may or may not be proclaimed publicly, but there will be some sort of regulatory explanation as to what transactions will be defined to mean in both of these contexts. So to take the example of WeChat very briefly, there's this huge looming question because of what I take to be either strategic ambiguity on purpose or poor drafting in the WeChat order. There's language in there, a clause that at least arguably seems to touch Tencent more broadly, and that set off fear among all the Fortnite players of America that somehow it'll be illegal to play Fortnite because Fortnite's owned by a company where Tencent has an investment. Maybe we'll find out in the WeChat context that, okay, so only WeChat is touched here. In the TikTok context, the more interesting questions have to do with whether the prohibition on all transactions will merely have the effect of, for example, forbidding the App Store and Google Play to offer the app any further. Certainly, I think it will do that. It will have the effect of forbidding the companies that lease server space to TikTok that enables TikTok to actually operate within the United States. It's going to kill those contracts. Maybe there'll be an exception for lawyers to still represent TikTok USA. I don't know. But everybody who's got a contractual relationship with TikTok is going to find a lot of interest in the Commerce Department's ultimate determination of what's in and out. And then, of course, there's all the people like my kids who have TikTok on their phone. That's not going to disappear from their phone. Can they still use it? I don't think it's actually going to still work because the server is going to be down. But if somehow it is still working, if there's some workaround that's in place, does the use of the product count as a forbidden transaction? I will tell you that, as I mentioned in the outset, that the Secretary of Commerce was promulgating generalized regulations under the May 2019 executive order. And in that regulatory process, there's been some back and forth in the notice and comments from the public criticizing the possibility that users of foreign communication services might be touched by a sanction under this. But the word use is in that draft regulation. It's not published yet, and it may not be what the Commerce Secretary does for TikTok, but that's a live issue. And I think if they really want to come down hard, they could let it be known. If they're really trying to force the sale, certainly they could let it be known that that too is on the table. With TikTok, there is the sale is the off-ramp. Maybe it all goes away. With WeChat, there's no off-ramp. Nobody thinks WeChat's going to be spun off into American operations, that Tencent's going to sell it to Twitter or something like that. So that's where the action's going to be when we get to around September 13th or whatever it's going to be.
Great. I think we should probably do just one more question, but I wanted to ask Tiff of this, the possible transactions with Tencent, which investments include into lots of gaming enterprises, for example, seems to be hugely concerned. Ordinary people think about this and what the president's about to do. in 45 days? Should we stop playing Fortnite? Should we find other games? Should we find other apps? What's your suggestion?
So I personally don't use either app, but I know plenty of people who do. And I think that right now there is no way to know exactly what will happen. As Bobby just mentioned, we don't know exactly how anything will actually be enforced, if it will be. And this administration has a history of releasing executive orders and then acting on them in ways that are much less controversial or much less impactful than we might have expected. So for now, if you are a user of one of these apps, I would urge you to read up on what's actually going on. So you understand the privacy concerns, you understand the speech concerns. You have to understand for yourself whether or not you're comfortable with your data, your behavior on that app, potentially being sent to China, to the Chinese government. You have to think about whether or not you're comfortable being part of a social media platform that might, for example, censor political voices, that might censor or de-incentivize people of color, queer people, disabled people, and so on. So if you are part of TikTok community and you really love it, and you want it to remain an entity that exists regardless of ownership, I would also urge you to try to get the platform to do better. And this is something we've seen actually work out for some other platforms, that when the users are upset about something, if they speak out in terms of asking for privacy, asking for more content moderation, transparency, that can change the app. And if you have an app that has better content moderation, better transparency, including algorithmic and AI transparency, and better privacy protections, that app will be less likely to be cautioned by any of these various US legal enforcement regimes we already have. And by the way, we do have other processes besides national security processes to make sure that these apps comply with privacy and speech laws. So FTC enforcement, for example, is something that has already begun against TikTok. So these are things that users can do. And if you are a user of WeChat, which will always be a Chinese company, at least for the near future, I wouldn't urge you to stop using it, but you might want to consider an alternative just in case.
Great, thanks, Tiffany. So I wanted to respond here to a question that is targeted at me. So I just want to make sure that you feel heard. Anne Broom says, it seems like you're supporting TikTok exactly because, to use your phrase, you applaud it as a tool to humiliate the president. So I was pointing out that the social media app TikTok here has been used in ways that are humiliating the president. And it should make us nervous, I think, in an election season with weird 45-day requirements to divest, which strike me as not the usual timetable. CFIUS was the system that was happening. It wasn't happening fast enough for Trump's purposes, and he has found a way to upset the principal social media app in which he doesn't have a huge platform. It's not supporting him. And I think that's hugely concerning in an election season. And if he had said, for example, this should all happen after the election, then perhaps it would be less of a political football. But he's created this in the election season, and I think that is problematic. And so I wasn't, I am not a supporter of Donald Trump, and I'm public about that. But my point was that this app has been used to humiliate him again and again. And if just all you have to do is suggest that you watch videos of Sarah Cooper or the kids or the K-pop fans who used it to, to stuff tickets so that Trump would falsely claim that he had 1 million registrations for his Tulsa rally. I think that clearly raised some of the hackles. And I think it's hugely concerning that these decisions are being made by the president himself. and you have a American company, Microsoft CEO, calling the President of the United States to ask permission to do a M&A deal. Those are unusual steps, and they shouldn't be happening during the course of an election, and I think that is hugely problematic. So I'll let Julian or Bobby respond to that in particular, and
I'll let me just quickly just say, I do think that you're right. It's election year, everything shouldn't do so. Although I would say that, I mean, there are things going on in U.S.-China relations that are affecting this timing as well. I think the actions of the Chinese government in Hong Kong were unexpected, surprising, shocking, and recent, and have been driving a lot of the flurry of U.S. government actions that came out, and also the timing of the trade deal, the pandemic. So I agree with you that it is. I think it's bad to do this during the election year, but I'm not convinced it's totally driven by that, because I think, like I said, to me, this order is about the Chinese government. It's not about TikTok. It's not even about Trump necessarily. It's about which is a bigger deal to me, anyways, which is the precipitous decline of U.S.-China relations, so that we're heading toward the old Cold War Soviet Union model. And if you would imagine the Soviet Union had an app that 100 million Americans looked at, you would. During the Cold War, you could imagine that would, that there was a precipitating event that sort of caused those relations to collapse. It's not shocking to me that this order came out at this time. But I agree. Look, it's probably mixed motive, right? And hey, it's also election year, right? But I do think that there are other things going on besides domestic U.S. politics.
I'll just add that it's worth underscoring that no conversation like this could possibly take place in China about an American company being kept out, an American communications platform being kept out of the Chinese market. The playing field isn't level. This wasn't the first move in the game. The status quo before this happened was a very unlevel playing field in which American companies have nothing remotely like the access to their market that they've got to ours, and that's worth bearing in mind.
Tiffany, any final thoughts?
So one final thought. I think we've spoken a lot about the equivalence or false equivalence of the US companies and the tech companies and these Chinese tech companies, right? So they both have privacy issues. They both sometimes have content moderation issues. And we've spoken about how China blocks pretty much every US-based app or tech company from operating, internet company from operating within China. So it isn't equal. It's not a level playing field. But the issue is that if we want to hold ourselves out to a higher standard, if America wants to be a shining city on a hill, the defender of democracy, and the staunch supporter of free and liberal rights, democratic rights around the world, then we have to do better than China. So that's something that's really important to remember. It's not necessarily that we have to do the same as China or to create equality in terms of our economic positions towards technology, but we should be thinking of our global norms as well.
Great. Well, thank you all. And I'm sorry that Hina, I think she lost her connection in the middle of this, so I apologize for that failure, the technical failure. But thank you all, Bobby, Julian, Tiffany, Hina, Hillary, and I also want to thank Devin behind the scenes, who has been terrific in making all this possible. We had something like 341 participants today. And so there's a lot of concern about this, a lot of interest, and I think this is going to be remembered as a very significant moment in global internet norm making, as Tiffany has pointed out. And I think we should, I think myself that we should hold ourselves to a higher standard. But it'll be really fascinating to see how this all plays out. Thank you all so much.
Thank you.
Thanks. Thank you so much. Thanks.